of marriage, the High Court has ruled. Justice Asenat Ongeri, in her verdict regarding a matrimonial dispute, said that even if a man or a woman proves that he or she got a child with the other, a paternity test cannot be the basis of an argument that the two are legally married. Beldin Waliaula tells us more.
In a case presented before the Kericho High Court, a woman codenamed FCR told the courts that she lived with a man for 20 years and has 5 children with him. The union later crumbled and she was shown the door by the man she thought was her husband. The man later remarried. Now, for FCR to prove her marriage to the man, she asked the court to conduct DNA tests to ascertain the children belonged to the man. A request that was dismissed by the court, where the judge said she cannot use children as evidence of a marital union. In her judgment, Justice Asenat Ongeri said, and I quote, "The applicant, FCR, applied to the court seeking DNA tests to be conducted to prove the paternity of her 5 children. I find that proof of paternity is not evidence of a marriage. The fact that a man and a woman sire children does not prove the existence of a marriage."
Mimi ningeonelea ule mama apatiwe kitu kwa sababu kama ameishi na mtu miaka 20 itabidi agawiwe mali kidogo kwa sababu amewesti muda mwingi sana na kukaa na huyu mzee.
Kama mtoto wako na mama iko na wote ni wa mzee, kama vitu itagawiwa, igawiwe watoto. Ni watu wazima waendelee na maisha.
Before mtoto azaliwe lazima kuwe na makubaliano, lazima iwe ni ndoa halali.
According to Justice Ongeri, her argument on the children would only hold water if it was in a child maintenance or succession case. According to the woman, it's during the 20 years of cohabiting with the man, they acquired several properties under his name. The bone of contention is 5 acres of land in Kericho, 10 acres of land in Burgei Bomet, and 18 acres in Nakuru. The woman submitted to court that she made a substantial contribution to the improvement of the properties by cultivating, tilling, weeding, and tending to the tea bushes on those land parcels when the man was away working. Therefore, she is entitled to an ascertainable interest in the properties. In his response, the man denied everything. He argued that he never had any children with her and never cohabited with the woman, adding that there was no customary marriage.
Whoever has the marriage certificate will be recognized as the legal wife because 1, she has to prove she's a wife. Okay, she has to prove she's a wife. Then 2, she has to prove her contribution to that property. So maybe what could be the saving grace is like if she knows, like maybe do you know that sometimes even wives don't have copies of these title deeds, like you don't even know what you're fighting for in the first place. So it is important that you as a wife, you as a spouse, you are aware of these documents.
Justice Ongeri, in her judgment, stated that there was no evidence that either the man or the woman had consented or intended to marry. The judge also found that although the woman had argued that the properties were bought while they were together, the woman did not prove she had an interest in the same.
Kutoka 2014 mpaka 2016 watu waweza kuchukua cheti ya kuregister ndoa zao. Sasa utapata ya kwamba Supreme Court ikikuja mwaka wa 2023 ikipeana uamuzi inatumia ile assumption ya kwamba kila mtu ameweza kuregister ndoa yao, lakini haitasahau hata koti zikienda kupeana uamuzi zitakuwa zinachukua kila kesi na ile maneno yote kesi imekuja nayo.
Beldin Waliaula, KTN News.
After the break, life and